Bishop.
Mr. Speaker, I ask unanimous consent that all members may have 5 legislative days in which to revise and extend their remarks and to insert extraneous material on H.R. 7511.
Without objection.
I yield myself such time as I may consume.
The gentleman is recognized.
Thank you, Mr. Speaker. Today, the House says the name Laken Riley through H.R. 7511, the Laken Riley Act. On this day, 2 weeks ago, the life of a 22-year-old nursing student, Laken Riley, a beautiful and vibrant young woman, came to an abrupt and shocking end, a totally unnecessary end, when she was abducted from her morning run around Lake Herrick Trail on the campus of the University of Georgia in Athens and brutally killed, beaten to death and to a state of disfigurement by a criminal alien whom Joe Biden and Alejandro Mayorkas were under legal obligation to detain. Laken's failure to return home alarmed her roommate, who called police. Police found her discarded body in the woods off the running trail, her skull crushed. Last Friday, Laken's parents laid their daughter to rest, their lives destroyed by the senseless and depraved actions of a criminal who should not have been here, and the callous indifference of the President and the Secretary of Homeland Security. Venezuelan Jose Ibarra illegally entered into our country across the southwest border in 2022. The Biden administration released him just like millions of others, paroled him into the country to roam wherever he pleased, rather than detaining him as the law required. Jose Ibarra roamed to New York City. There, in August, NYPD arrested him for driving a scooter without a license, with a child on board, unprotected by a helmet. And an independent obligation arose for Homeland Security to detain Mr. Ibarra, namely, that he had committed an offense involving moral turpitude by endangering that child. But NYPD released him, and Homeland Security did nothing. From New York City, Jose Ibarra roamed to join his brother Diego, another criminal illegal alien, in Athens, Georgia. Athens police arrested Diego in September for driving while intoxicated and without a license, also an offense involving moral turpitude, which required detention by Homeland Security. But Homeland Security again did nothing, and Diego too was promptly released. In October, Jose and Diego joined forces to rip off the local Walmart, and it must have been quite something for them to be arrested for shoplifting in this day and age. But arrested they were, and another basis in law arose for mandatory detention. Specifically, 2 or more criminal offenses by each of them involving separate criminal acts. Again, Homeland Security utterly disregarded Congress's statutory command and did nothing. The Ibarra brothers were set free upon the community again. In December, a final chance came to prevent Laken Riley's fate. Athens police arrested Diego again for failure to appear for a fingerprintable offense. Why didn't they arrest Jose? Who knows? Maybe they figured, what's the point? Homeland Security will just continue looking the other way. Even though Diego was also now an absconder, he was released again. And the big bureaucratic Department of Homeland Security did nothing. Secretary Mayorkas asked whether Jose Ibarra should have been deported before he beat Laken Riley to death, answered blandly that his agency, quote, works closely with law enforcement to ensure individuals who pose a threat to public safety are made the highest priority for detention and removal. Which reminds me of the more than 30 times Secretary Mayorkas testified to Congress under oath that the border was secure. What the Secretary omitted to explain was the law he laid down in September 2021, the memo to the Department of Homeland Security employees, where he instructed that the grounds specified by Congress for detention would never be the basis standing alone for any detention by Homeland Security. the law according to Alejandro Mayorkas. Today, the Laken Riley Act presents two simple and straightforward amendments to law to break through the Biden administration's brazen, defiant, and reckless disregard for Laken Riley and all the other vulnerable Americans out there victimized already or soon to be victimized. First, it specifies theft offenses as a ground mandating the Secretary of Homeland Security to take into custody criminal illegal aliens like Jose Ibarra and to issue a detainer request to local law enforcement. How hard is that, right? Shouldn't illegal aliens required to be detained at the border in the first place, who go on to engage in thievery in our country, be detained and removed? Who could disagree with that? But if H.R. 7511 only added another detention mandate to the slew that Secretary Mayorkas is brazenly defying even today, it would be an act of futility. More statutory commands to an administration that is lawless, and it would do nothing to honor the life and memory of Laken Riley. Therefore, the other essential element of this bill is to confer standing upon state attorneys general to bring civil actions against open borders executive branch officials who refuse to enforce the nation's immigration laws. This provision comes from H.R. 7322, the Sue for Immigration Enforcement Act, introduced by me and by Chip Roy. It will empower states to hold Homeland Security accountable in federal courts for flouting mandatory detention requirements, the limits of parole authority, and visa sanctions against countries that refuse to cooperate with repatriation of illegals removed from our country. This responds to the Supreme Court's ruling 2023 in United States versus Texas that states lack standing in such cases. And it follows the roadmap set forth in the court's opinion in that case, inviting Congress to cure this standing defect by specifically authorizing such suits in statute. The provision confers standing upon a narrowly defined set of plaintiffs, the states, and authorizes the judiciary to grant redress. As such, this legislation will ensure that harmful abuses of our immigration laws, in fact, those policies set forth by the Biden administration that are in direct conflict and contradiction with the plain meaning of our laws, will not go unchallenged. H.R. 7511 also honors Laken Riley's life and those who mourn her loss, as well as all of the other victims of the Biden border crisis. No law passed by this body can bring back Laken or take away the pain suffered by her family and countless other victims of criminal alien crime. The Laken Riley Act, however, will ensure that illegal aliens who commit theft offenses, as Laken's alleged murderer did, cannot be shielded by the Biden administration's continued reckless, callous indifference. I reserve the balance of my time.
Gentleman reserves.